Hello, everyone, and welcome to Uncivil Law. For today's case, we have Donald Trump being sued because of his business dealings and unfair competition. This is the case of K&D LLC trading as Cork versus Trump Old Post Office LLC and Donald Trump. In this case, Donald Trump owns a hotel in DC, and they're competing with other people. And one of the people that they're competing with is saying it's unfair competition. So we're going to read this case, read what it has to say, and decide whether or not President Trump has unfair competition problems. Let's get started with this. The Cork Wine Bar, which I have been to, a restaurant on the edge of the District of Columbia's U Street corridor, competes with President Donald Trump's eponymous Pennsylvania Avenue Hotel. Cork brought the suit in the Superior Court of the District of Columbia, alleging violations of common law and unfair competition. The District Court denied the motion to remand, then dismissed its complaint for failure to state a claim. We affirm. At the motion to dismiss, we accept all that the complaint argues as true. K&D owns Cork. The Trump International Hotel is a business held in trust for the sole benefit of President Trump. I'm not sure that's 100% true factually or not, but that's what they say. Because I was under the impression that, it may have been transferred to his kids or whatever, but whatever. Trump's Old Post Office LLC operates the hotel and holds the lease on the historic Pennsylvania Avenue structure. The hotel, which opened in 2016, features an event space, a restaurant, and lounge, and competes with Cork. It's also a very, very, very nice building. So whatever else you can say about the man, he knows how to build a hotel. It's very nice. Cork noticed the competitive balance shifted towards the hotel after the 2016 election, when the hotel began to attract more of lobbyists, advocacy groups, and diplomats that the Cork had relied on to fill its event calendar. Citing the federal officer removal statute, President Trump filed notice in federal court. Cork moved to remand, but the district court denied in a minute order. Once the federal court, President Trump and the hotel moved to dismiss Cork's failure to state a claim. Okay, so originally President Trump was sued in state court. Of course, this is DC, so it's DC, but state court. You know what I mean, right? So, but there is a there's a statute in federal law that basically says, in so many words, that under certain circumstances, federal officers can get cases transferred, or what's called removed. I don't know why they call it that, they just do. But they can get cases removed, transferred to a federal court. And then one of the reasons is because they're federal officials, and there's all kinds of issues with state courts interfering with the federal government. So what it basically says, okay, as part of the supremacy clause kind of thing, if you're a federal official in a certain circumstance, you're being sued in state court, absent any other reason to go to federal court, you can still transfer to federal court, because we're concerned about the federalism issues that would apply if the state court hears it. So President Trump asked this case to be transferred to federal court out of state court, and it was granted. And the other side asked it to be transferred back, which they didn't do, and so they dismissed it for failure to state a claim. So that's where we are. The district court granted the motion to dismiss, concluding that Cork's allegation of unfair advantage caused by the hotel did not amount to a cognizable unfair competition. Neither the president nor its hotel had interfered with access the court had held. Instead, Cork complaint boiled down to an assertion that business with famous proprietors cannot compete fairly, a proposition alien to unfair competition, and Cork filed a timely appeal. So, as a matter of unfair competition, no, this is not going to work, right? So let's just remove the president from this example and make it simpler. I don't know, you're a local mom and pop, Italian food restaurant business operating somewhere, and for reasons passing understanding and not really relevant, right across the street from you, insert the name of your favorite celebrity chef in this sentence, opens a restaurant and makes it a huge gala and whatever, blah, 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 right? So, you say, well, people are going to go there just for the name. And the court is like, yeah, and that's not unfair competition. If people like the name, if they like the business because they have a good association with the name, that's their right. That's not unfair competition. So, you're saying, well, I can't compete with that. And the court says, we don't care that you can't compete. People go to businesses for all kinds of reasons. And name is one of them. If a really famous name opens, then okay, so be it. So if people want to go to Trump because they associate positive things with Trump, that in and of itself is not unfair competition. People have the right to patronize a place called Trump if they want to, right? It's not unfair competition. They're not. Are they barring your doors? Are they doing something to directly interfere with you? Are they shining bright lights into your place? Are they shouting loud music? Are they saying nasty things about your business? Or what are they doing? Oh, they just opened a hotel that's really competing with me. Okay, well, I don't know what to tell you. That's business, man. So now we need to discuss whether or not this should be heard by a federal court or state court. So let's discuss whether removal to federal court was proper. If removal was proper under the federal officer removal statute, the federal court has jurisdiction over the claims. The statute allows any officer of the United States to remove to federal court a state suit that is for or relating to any act of color of office. So if it's related to your office, fine. We apply a two-part test. First, the officer must raise a colorable federal defense. Second, the officer must show the suit is one for or relating to any act under office. We must construe the statute liberally in favor of removal. So, okay, there's this test we're going to do, but we're interpreting it to favor removal. Our default is we want to remove, because that's what the federal law requires. And so it's like, we're going to interpret it liberally. We're going to interpret it to favor removal. Okay, let's find out if Trump can remove or not. Removal under the law constitutes an exception to the generally well-pleaded complaint rule. Federal jurisdiction generally exists only where a federal question is presented on the face of the plaintiff complaint. So normally we look to the plaintiff's complaint and what it has to say, right? But this is an exception. This has nothing to do with the plaintiff's complaint, because normally the plaintiff is master of its complaint, right? Normally the plaintiff can construe its complaint, write its complaint. It is master of its complaint. But not so much here. Like all good rules, it has an exception. There is an exception. The plaintiff can do nothing to forbid this. This is a statutory right. I'm a federal official. It has nothing to do with your complaint. I'm going to invoke it. You can't prevent it. Okay? Under the law, a suit may be removed despite non-federal case of complaint, because this started out as non-federal, and nothing about it is federal inherently. You know, in its start one existence, it's a dispute between two businesses and two individuals. There's nothing about it that's federal. It's not even a dispute in jurisdiction. They're both in D.C. As long as defendant presents a colorable federal defense. The federal defense need be only colorable, not clearly sustainable. So as long as you have any federal defense at all, you know, the federal court will hear your complaint rather than the state court, which again in this example is the state of D.C., which isn't a state. But, you know, you understand. President Trump raised two federal defenses. First, he argues that the district may not impose legal conditions on his performance as presidential duties. Second, he claimed absolute presidential immunity. Because we find the first defense colorable, we need not address the president's alternative immunity based on amendment. So he's like, the defense is this interferes with my duties. How? I don't know, but the court finds it colorable. The Court of Appeals finds it colorable. So it's like, yeah, it's like, okay, somehow this would interfere with duties. Maybe we'd have to do depositions or whatever. It's like, so yeah, this might interfere. So there's some colorability, sure. The Supremacy Clause restricts the power of the state and local governments to regulate federal offices. Fair enough. This is a Supremacy Clause issue. Federal government has supremacy. This is a federal official. This is a state government trying to interfere. So, there's problems there. Claiming his defense relies on a prior case, President Trump contends that Cork's version of what the district law requires works to regulate the holding of the office because it would forbid federal officials from owning interest in a business. Okay. Any officer with the stake would face civil liability because of his official status, which amounts to conditioning the lawful exercise of power on compliance with local legal requirements. They say we think it's colorable, and so do I, to be quite honest. It's like, look, if this upheld, this would mean that any federal official couldn't have a local business. And there are a lot of federal officials with local businesses, not the least of which are quite a few members of Congress. Lots of members of Congress have local businesses, and they're arguably federal officials under this doctrine. And there are lots of government officials that have businesses of some kind. There's a lot of business people in government, for better or worse. And saying, and if we allowed this isn't just an issue with DC, of course. This isn't just an issue with DC. It happens to be DC, but it's not just DC. Because if the Trump Hotel existed anywhere else, it would be the same issue. Do we want the city of Spokane to be able to do this? Do we want the city of Des Moines to be able to do this? Do we want the city of whatever to do this? It's like, no. We don't want a federal official's ability to do things being conditioned on whatever random locality law. So that it's like, you can't own a business and be in the federal government. It's like, you can't do this to me. I'm a federal official. You can't condition my federal exercise on what I have to comply with every city and every county and every state. No, it doesn't make sense. So is it colorable? Yeah, it makes sense to me. To be clear, we make no position on the merits of the defense. We only conclude it's colorable. So again, like, is it ultimately right is not the issue. It's colorable. It's arguable. It's reasonable even. Is it winnable? Who knows? But that's not the issue. All we're trying to determine at the moment is whether or not we have jurisdiction. And we do, because we have a colorable defense. As the second step, President Trump must show the suit was for relating to any act of color of office. To satisfy this requirement, the officer must show a nexus, a causal connection between the charged conduct and the asserted authority. Put differently, the circumstances that give rise to liability must encompass the conduct of office. President Trump characterizes Cork's suit as an action for or relating to the act of him simply holding office, which is a fair point, right? Cork presumably wouldn't be suing him if he didn't have office, so that's okay. He argues that his position as president is a necessary condition for the theory of liability. An assumption of office is what caused the unfair competition to begin with. Yeah, I mean, that's a fair point. We agree. The fact that President Trump is president is indispensable to the claim. The complaint expressly targets the unfair advantage from the hotel that he gained from being president. The fact that he's president is material. Yeah, okay, very good. We now turn to the merits. Having to determine we have jurisdiction. Fair enough. The district court dismissed the complaint for failure to state a claim. Our review is de novo. When considering common law claims, federal courts must apply the existing law. We have no power to alter or expand the DC or state tort law. Yeah, so a federal court is interpreting the state law or the DC's law when it comes to tort, because torts are almost invariably a matter of state law or DC law, right? So we're considering the common law. The federal court does not have power to expand the law because it's the state law, so it's something that they it's a function of their state. So all they can do is apply the law as it is. They can't modify it. They can't extend it. All they can do is apply it. It's federal law. Federal courts have their limits, man. When considering common law claims, federal courts must apply existing law. We have no power to alter or expand the scope of law. The district court case elements do not define unfair competition in terms of specific elements, but rather by way of example, describing various acts that would constitute a tort if they resort. So they don't say, here are the elements, they do it by example. Okay. We've previously identified 3 species of unfair competition under district law. Passing off one goods isn't fair of those of another. These are someone else's goods, yeah. Engaging in activities designed solely to destroy a rival. Barring their business or stealing their customers or, that kind of thing. Using methods that are independently illegal. Okay. Later, in its most recent statement on the subject, the District Court of Appeals listed forms of unfair competition: defamation, disparagement of comparator goods or business methods, intimidation of customers or employees, interference with access to business, threats of groundless suits, commercial bribery, inducing employees to sabotage, and false advertising or deceptive packaging. All these sound pretty bad, yes. Cork makes no meaningful attempt to square its unfair competition with the district's law. The gravamen of Cork's complaint is so long as the president retains a stake in the hotel, Cork cannot fairly complete because of the perception the hotel patrons will receive favorable treatment from the Trump administration. Although Cork suggests in passing that President Trump and the hotel are impairing competition and interfering with access, it claims bear real resemblance to the examples listed in prior case law, and Cork shows no examples showing they follows an example. So, you make some sort of passing example of how they're interfering with example or interfering with access, but how? They don't seem to be doing anything. Are they are they scaring people away? Are they playing loud music? Are they shouting things from the? What are they doing? They're not doing anything. They're just standing there and welcoming people in. Not enough. We see no reason to conclude that district common law recognizes anything like Cork's unfair competition claim. During oral argument, we asked Cork to cite any case from any jurisdiction in which a plaintiff successfully advanced a similar theory, and they concede no such case exists. So not only is there not one in DC, there's no one anywhere. Okay, that's good news. That's promising, right? Cork's case cannot survive that concession. Instead of citing case law, they appeal to the ongoing evolution of common law claims like unfair competition and cite generic passages from the second and third restatement of torts. Cork's allegations may one day constitute unfair competition in the district. Maybe one day soon, given everything we know. But we must take the law of appropriate jurisdiction as we find it. Law is what it is in DC. We have no power to modify it. Cork offers no indication the common law, or indeed any jurisdiction, has evolved to encompass this theory, nor does it, to my mind, really make sense on first blush. Again, it would seem to apply It applies to Trump, it would apply to any federal official. And maybe it should, but again, there are a lot of Congress people with businesses, so I don't know. We therefore affirm the district court. In fairness, Cork did not plan on having its common law claim adjudicated in the court, incapable of adopting the common law to fit these allegations, because it was originally filed in state court. But now we're in federal court. All right, now that it's been properly removed, transferred to federal court, we urges us to certify the question, namely the validity of the unfair competition, to the Court of Appeals. Okay, so you want to certify the question, which is to say, we want to ask a court of competent jurisdiction, what is the law? Because we're not the masters of this law. We're applying someone else's law. So one of the things you can do is called certify. The Supreme Court can do it. Anyone can do it, really. They can ask one state or one jurisdiction is trying to interpret the law of another state or another jurisdiction. So one of the things you can do is ask a certified question. You can say, hey, other jurisdiction, what is the law on this? So that we can go apply it. That's an option. Okay. We decline this request. Not today. The decision to certify is discretionary. And the most important consideration guiding discretion is whether we're genuinely uncertain about the correct answer. When the law provides a discernible path, we follow it. Not for least the reasons that there's no law anywhere that seems to say this at all. So it's like, how can it be a theory in DC? It's not a theory anywhere. When the law applies the discernible path, we follow it. The law provides that we follow the path, demonstrating district law does not recognize the claim, and Cork fails to identify any cause suggesting an alternative route. Moreover, Cork did not argue this case is one of extreme public importance, a traditional element of certification, and therefore the judgment is affirmed. So that's the end of our coverage of the case of K&D LLC trading as Cork versus the Trump Old Post Office and Donald Trump. In this case, we learned that Cork owned a business that was suddenly being competed with by the Trump Hotel. And he was sad because people were going to the Trump Hotel. And he said, well, it's only because of the name. And so I'm going to sue. And the court said, what are you talking about? That doesn't make any sense. What does that mean? They have the right to own business. And he said, but I don't want them to. And he said, well, I don't know, compete harder or something. So Cork will have to try harder to appease the denizens of DC. Not that I think it will be that hard, because, there's lots of business, and I would imagine there's a lot of business still for Cork. So, try harder, compete harder, and that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.